Good morning. Welcome all to Assembly Judiciary. I'm Bill Monning, sitting in for Chair Mike Fuhrer this morning. We are going to start as a subcommittee, lacking a quorum at this point, and we will be starting with item number 10 with Senator Wright present. So if you want to come forward, Senator Wright. And just a reminder to all those presenting today, we limit testimony to 2 witnesses per side, 2 minutes each. And then people can add on their support or opposition, stating their name and organization. As mentioned, we're starting as a subcommittee. We'll be joined later by Mr. Jared Huffman, sitting in for a vacancy this morning. And Senator Wright, item number 10, SB 1355.
Chair and members and staff, 55. You've got new amendments. I appreciate the work of the staff to get this as something that we can work with. You know, simply put, we're trying to implement a recommendation about how we process child support payments in the future for men who've been incarcerated. North Carolina does this program. Want to fast forward because they're witnesses, and I don't want to just stretch out a lot of time. So let the witnesses go ahead, and then I'll be available for more questions if necessary, Mr. Chairman.
Mr. Chair, Mark Weideman on behalf of the California State Bar Family Law Section. We support this bill. The bottom line is that an incarcerated individual would have the right to petition for the court for a change in their support payments, but they often don't have the means or the ability to access the courts. And so what this bill does is it sets up a process and puts the process in place to basically function automatically. Suspend those payments while the person is incarcerated beyond 90 days. And then if the person does have the means, even though they're incarcerated, it doesn't give them a suspension. So that was amendment language that was taken that we think improves the bill. But once they're back out of jail, their support payments kick back in. And this is a process that should be automatic because we have a situation where people are developing arrears while they're incarcerated, while they're unable to pay these support payments, and it creates significant complications once they get out of jail. And so we think this is a good improvement in the law. It's something that should happen automatically. It'll streamline the system and the family courts, and we appreciate Senator Wright for bringing this bill forward.
Good morning. Susan Dunlap, Program Manager with Placer County Department of Child Support Services. We too support this bill. It would certainly allow the local child support agencies a more expeditious manner in modifying the support for incarcerated obligors. Normally the process takes several months, and this would speed that up, as well as make sure that we're setting and enforcing guideline child support. So if somebody doesn't have the means to pay while they're incarcerated, their guideline child support should reflect a zero obligation. And then this bill also modifies it back to the amount that it was prior to incarceration upon their release. Thank you.
And Mr. Chair, one of the things that we hope occurs over the long haul is that we'll improve the collection rates for counties and thereby increase the amount of federal dollars that we receive, because we don't have a disproportionately high number of people who are not paying, only to realize that it was money that was never collectible in the first place. And there's a federal reimbursement that's based in part on the collection rates of the counties, and we often place ourselves at a disadvantage for money that we were never going to get in the first place. This will help us with that, and in the long haul, you can't score it yet, but it'll also help improve the collection rate and the reimbursement rates from the feds.
Thank you, Senator. Are there other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, let me see if there are any questions from my colleagues. Yes, Mr. Knight.
Your colleague. Just a quick question. If someone loses their job and they're obligated for child support, what is the process there? Obviously, they can't afford the child support. So, what is the process? How long does that take to get a court date or a hearing to amend their child payment?
Well, it's going to depend on the county that you're in, but if you lose your job, it is a qualifying circumstance to petition the court for a modification in child support. There are certain standards that apply. You have to demonstrate that you're out looking for a job. and trying to get yourself in a position where you can continue your child support obligations. But there is a process in place, and the timing is going to depend on how quick the courts can get to it.
Okay, and I understand the senator's idea here. It's a good idea. If you're going to be in prison for 5 or 6 years or something, you're obviously not going to be able to make child support. I'm just wondering about the timing issue. If this goes into place, that automatically allows them to get this change in their child support payment, correct?
That's correct.
Okay. And then when they leave...
Provided, Assemblyman, that they don't have other means.
Right.
So
right. And I understand that.
If you popped Ken Lay and he got $2 million, laying in an account, we still get the child support.
Right. I understand that. And then when they leave prison, is there some other mechanism to allow them to have, a 6-month period or something, the time that they're on parole and the time they get a job or something like that? Or, I mean, I'm just wondering about...
Currently drafted. What we didn't want to do is kind of create a kind of get-out-of-jail-free card, so to speak. So it resumes when he is released. But again, what he would have to do upon release, because he'd be able at that point to go into court and seek an additional modification. So upon release, he would have the obligation or the responsibility. And I'm going to... Most of the men who end up in short shrift in this environment just simply don't take care of the business. I mean, to your point, if you lose your job or if you have a substantial reduction in income, for example, you get a furlough day at your place of employment, you can, in fact, go to court on your own and seek a modification based on either losing, being laid off, or having reduction in income. What happens is that many people don't. And the clock begins to tick, and once you don't act responsibly, you can't go back and say, oh, I actually lost my job in January. Well, the period between January and June, that's your fault. As soon as you go in and apply, then you have acted responsibly, and even if it takes a while before you get the hearing, the date that you apply is the date that's considered when you get there. Now, if you lose the modification argument, well, that's a different drill. But the court recognizes your ability to act responsibly, and they treat guys fairly. But the irresponsibility of many obligors is not something that we're going to be able to fix in statute. That's a responsibility that you have and you have to take care of.
Thank you, Senator Wright. Do we have another witness who wanted to register support?
Yes, Liberty Sanchez on behalf of the California Public Defenders Association in strong support of this measure. I don't know if you've already had sufficient testimony.
We have, so...
Would like to register my support.
But thank you for registering your support. Appreciate it. Thank you, Senator Wright. And just before you close, I think just in this recent exchange, it would seem to me that we do want the obligation to continue when somebody is released in the interest of the children. Right. And even though I realize it's a tough job market, particularly for people on parole, if we look at this through the lens of the children, that obligation, if not modified, accrues to the interest of the children, so that when that person gains employment, and if there is a wage garnishment, it can be calculated to protect the children's interest.
Right. And we wouldn't do that. I mean, and I'd say, just as we do in a number of other instances when a person is released, hopefully what we'll build into the parole process is that the parole officer would inform him, okay, you need to now go to the court and deal with your modification, just as he would about your driver's license or other things that would attempt to make him a functioning part of society again. So, I mean, ideally it'll be something where that parole officer would have information about that, inform him of his obligation to go and do that. So we're not, this is not an attempt to protect him in perpetuity and deny that child the right to what he or she should be receiving, but it's just an attempt, again, so that we don't have someone who's sitting in custody unable to earn any wage and watching the meter continue to rise, so that someone who made no income for 3 years walks out and has a $20,000, $30,000 obligation that becomes so insurmountable that they just go underground, and no one wins in that situation.
That's right.
Chair.
And you mentioned the added benefit that I hadn't realized of the federal contribution being impacted by the percentages of compliance. So thank you, Senator. Would you like to close?
I just asked
That
for
was
an
your
aye vote.
close. Okay. We're still convened as a subcommittee only. We don't have a quorum established yet, but once we do, we will entertain motions in support of your bill.
Thank you.
Thank you, Senator. And now we're going to go to item 9, SB 1269, by Senator Oropesa, and I believe she has a staff member today presenting on her behalf.
Good morning, Chair and members. Thank you for allowing me to present SB 1269 this morning on behalf of Senator Oropesa. According to the California Integrated Waste Management Board, more than 6 million tons of food products are dumped annually into our landfills. With our state's unemployment rate at nearly 13%, food banks and other nonprofit organizations are reporting unprecedented requests for food assistance. Unfortunately, donations have not kept pace with growing demands, and many food banks are having difficulty keeping their pantries full. Despite federal and state laws encouraging the donation of food by providing extensive liability protections and financial savings, many businesses are not eager to donate. SB 1269 addresses that fear by directing the Department of Food and Agriculture and the Department of Public Health to post information on their websites regarding federal and state liability protections for the donation of food. Additionally, businesses may be entitled to tax deductions, and that information will also be made available on their website. Thank you, members, and I respectfully ask for your aye vote.
Thank you. Any witnesses joining you today in support? That you know
I don't think they made it out this early.
Okay. And are there any witnesses in opposition? Seeing none, any questions from committee members? Hearing none, would you like to close?
Oh, thank you so much, and again, I ask for your aye vote.
Thank you very much. Again, we are convened as a subcommittee, and we will, once we establish quorum, take this up with appropriate motion. Thank you for presenting this morning. Okay, so. Okay, it appears we have no authors in the queue, bill authors. I would put a call out to all of those. We're going to keep the agenda open for the next 10 minutes, and if authors don't choose to present their bills today, we will put them over. So, 10-minute call. If you've got a bill before the Assembly Judiciary, please report to present. Thank you. Okay, just an update. We've got about 5 minutes left on my 10-minute warning, so if an author does not appear in the next 5 minutes, we will suspend matters until another time. So, authors, you have 5 minutes. Assembly Judiciary. Okay, we're going to go back into action here with item 6, Senator Simidian, SB 1166. And just before you present, Senator Simidian, I do want to point out to committee members on your committee analysis at page 6 of the committee analysis, there's a slight correction with respect to the amendment language. It should read on page 6 after line 37, insert, and then you have the italicized language related to the amendment. So the language is apparently correct, but the reference to where it's located, change it to on page 6 after line 37. We're convened as a subcommittee. Senator Simidian, welcome, and the floor is yours.
In 2002, California passed a security breach notification bill, which set the trend, really, for states around the country. And very simply put, it said, if you have somebody's data and you lose it, you have to tell them so that they can protect themselves. That was the bill, and it was, if I may say so, elegant in its simplicity. It was subsequently the basis for 44 other states around the country, Mr. Chairman and members, to provide similar security breach notification laws to protect their members of the public. And as I say, it has worked well because it has a light touch. It does not tell anyone how to protect the data. It simply says if the data is lost, you have to let people know, and they have to be able to protect themselves. Has the added benefit of giving people a real incentive to improve their security systems for the data. So now here we are 8 years later, and the question is, what do we know? And the answer is we know that it's worked pretty well, but we know that it could work a little bit better. 14 states have said, you know what, great in its simplicity, but one of the things that might have been helpful is if we had a little more clarity and specificity about what should be communicated to someone when they receive notice that their information has been compromised. That's what the bill provides. We have had a marvelous 4-year dialogue with this committee on this very topic. 4 years ago, I laid off, decided not to do the bill because then Assemblymember Jones was going to deal with a larger set of issues. His bill ultimately was vetoed. Then 3 years ago, we tried again, and Assemblymember Jones had a bill, and it was my bill was contingent on the passage of his bill. The governor didn't sign his bill, so the bill fell by the wayside. Then last year, we did a bill that was a standalone bill and managed to eliminate all opposition to the bill, got to the governor's desk, and the governor vetoed the bill. And if I may say so, largely because of a misunderstanding. There was a change in staff in the governor's office. So I went back to the governor's office this year and said, you know, I think there's just been a misunderstanding here. We're happy to work with you. Can we try again? They suggested that that would be wise, so that's what we're doing. We have essentially the same bill before you today, members, that had no opposition last year. There is one group who is a newly emerging group this year, the California Hospital Associations. They weren't concerned last year, but they are concerned this year. Fair enough. They took another look. They're concerned this year. I believe, Mr. Chairman, that the amendment that your staff has recommended. It will remove their opposition, and on that basis and with that understanding, I am prepared to take that as an author's amendment, and I respectfully ask for an aye vote. It would be good for the public, and it will mean this committee can stop hearing the bill.
Thank you, Senator. And now we'll hear witnesses in support. 2 witnesses, 2 minutes each, and then others can add on indicating their support. Please.
Lenny Goldberg, Privacy Rights Clearinghouse. We often get many questions from consumers who get breach notifications and say, what is this about? What does it mean? What should I do? And I think that what Senator Simitian's bill does is answer a lot of those questions. It actually is very reassuring. It says, here's what you had, here's what was compromised, here's who you can contact. And as he said, we were in a lot of discussions with various business entities and worked out these issues last year. So we strongly support the bill.
Valerie Small Navarro with the American Civil Liberties Union in strong support.
Thank you. Other witnesses in support? Seeing none, witnesses in opposition or some other status?
I would be a tweener. Thank you. Connie Delgado Alvarez with the California Hospital Association, and with the amendments that were suggested in the analysis and the new updated provision, we will be removing our opposition. We want to thank the author and the committee staff and his staff for their cooperation. Hospitals are doing everything they can to comply with confidentiality and all the notices. Thank you.
Thank you. Committee members, any questions? Seeing none, Senator, would you like to close?
Just 2 brief observations, members. First is, yes, the new language and provisions are consumer-friendly, but they're also business-friendly. One of the things we did when we did the original bill back in 2002 was we said it has to apply not just to the private sector, but also to the public sector. That if we were imposing any duty or obligation on the private sector, we wanted it to be on the state agencies as well. One of the things that we've heard from both the state side and the private sector side is additional specificity actually would give us a safe harbor. We would know that if we included that information, we had complied with the law. So while many back in 2002 argued for a little ambiguity in the name of flexibility, over time what we've heard from some in the business community is we'd actually like to know what is it we do, and as long as it's not burdensome, we need to know that if we do it, then we're compliant. So that would be helpful. And just on a bipartisan close here, Mr. Chairman and members, the original legislation creating California security breach passed out of the Senate and the Assembly back in 2002 on a unanimous basis, bipartisan support. This measure has passed 31-5, and I'm pleased again to say that with the help of the committee staff, there's now no opposition to the bill. Respectfully ask for an aye vote.
Thank you, Senator. We appreciate your presenting this today. We're still convened as a subcommittee, so we will hold that until we've established quorum. Thank you. Next, item 8, Senator Wolk, SB 1222. Good morning, Senator Wolk.
Good morning, Mr. Chair. 1222 is a district bill which will extend from July 1st, 2011 to 2012 the sunset date to allow the Solano County to continue collecting a fee on marriage licenses and copies of vital records to support domestic violence prevention efforts in Solano County. Many cities and counties are authorized to collect fees for this purpose, some on a permanent basis. Senator Wiggins' bill extended the program to 2011. We'd like to extend that with this bill to 2012 and make it eventually the case that we can do away with the sunset altogether as this program becomes solid and stable. I ask for your aye vote.
Thank you, Senator. Witnesses in support?
Mr. Chairman, other members, Paul Yoder here today on behalf of the Solano County Board of Supervisors. With me is Carolyn Thomas. She's the Director of the Office of Family Violence Prevention in Solano County. We're here to be a resource for you. I can't thank staff enough about their willingness to listen and be helpful on this bill, both sides of the aisle, and I would urge an aye vote. Thank you.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, committee members, questions? Hearing none, would you like to close, Senator? I think you
would
just
ask for your
did,
aye vote.
Okay.
And thank you.
And again, we will hold that until we've established a quorum. So thank you for your presentation this morning. Now we're going to move to item 1, Senator Flores presenting SB 392. Good morning, Senator Flores.
Good morning.
Welcome.
Good morning, Mr. Chairman. I will be brief, and I'd like to thank the committee staff for working with our office to help craft the bill. Very much appreciate it. This bill, members, authorizes the issuance of contractors' licenses to limited liability companies. LLCs, as you know, are desirable to the construction industry because they provide business flexibility as well as improve the state planning and profit sharing. This bill would require LLC contractors to follow all the requirements of the current LLC law, in addition to having the bill amended to require contractors to maintain an additional wage and welfare bond to further protect workers. It is sponsored by the Association General Contractors of California. And, of course, we have support, we believe, from the labor community as well. Our most recent amendments give us no opposition at this point in time. We do have Paul Gladfelty with us on behalf of the Associated General Contractors of California as witness.
Thank you, Senator. Yes.
Mr. Chair, members, Paul Gladfelty representing the Associated General Contractors of California. We are the sponsors of the bill. This is something we've been working on with the committee, and we commend committee staff and their hard work in reaching a compromise with some of the opposition. We added a bond for added protection for workers in case of bankruptcy situation, and I'm here to answer any questions, but we think this would essentially bring California in line with 38 other states, in which 39 states have licensure law. We're the only ones that do not allow for an LLC. Thank you.
Thank you. Other witnesses in support?
Good morning, Mr. Chairman, members. Julianne Burrells here on behalf of Associated Builders and Contractors of California in strong support of SB 392. We think this is good policy and certainly will expand and ensure that we have a reasonable number of contractors available here in California for the hopeful rebuilding of our state's economy. Ask for an aye vote.
Thank you.
Mr. Chair, Phil Vermeulen representing the engineering contractors and several other contractor associations. Strong support. Urge your aye vote. Thank you.
Thank you. Any other witnesses in support? Any witnesses in opposition? Seeing none, committee members, questions? Seeing none, Senator, would you like to close?
Would just ask for an aye vote.
Thank you. We will hold that. We are working to establish a quorum, so thank you for your presentation. And now we'll move to Senator Yee. Please come forward. Senator Yee has a number of bills for presentation this morning, item 3 being the first in order.
Okay.
I'm sorry, item number 2, SB 438. Good morning, Senator Yee.
Thank you very much, Mr. Chair and members. First off, let me thank your staff for their help with these and the other bills that we have before you. This is a rather simple bill. It basically says that the fact that you go into a charter school does not mean that you as a student give up your First Amendment rights, pure and simple. Nothing more, nothing less. I think you're going to hear from the charter school that, well, this is going to change their curriculum or this is going to be an intrusion. All of us here in the state of California understands that there are, in fact, public schools and these charter schools. Public schools, in fact, respect individuals' First Amendment, their freedom of thoughts. It seems to me that just because you go into a charter school, that you ought not to be checking those particular qualities of our democracy at the front door. And so with that, urge an aye vote.
Thank you. Witnesses in support?
Mr. Chair, members of the committee, Jim Ewert for the California Newspaper Publishers Association. We're the sponsors of the legislation. The situation, or the bill, deals with a situation that's detailed in the committee's analysis regarding a situation at Orange County's High School of the Arts, where articles were pulled by the administration based on its content. And The reason why we brought this forward to Senator Yee was it's our belief that just because a student attends a charter school doesn't mean that they have to give up their constitutional rights. And this legislature has spoken long and hard for many, many years about protecting student speech. It's not imposing its will by statute. It's essentially guaranteeing basic fundamental protections to these students, and we respectfully urge your aye vote.
Thank you.
Mr. Chair, Seth Bramble on behalf of the California Teachers Association. CTA is in strong support of this important legislation. We believe that free press is fundamental to a democracy, and that any act which has the effect of inhibiting the exercise of free speech or freedom of the press is intolerable, and for these reasons we urge your aye vote.
Mr. Chairman and members, Francisco Lobaco on behalf of the ACLU, a good free speech bill. Just a reminder, the statutes also apply to private schools, so makes absolutely no sense why it shouldn't apply to charter schools. We support the bill.
Thank you. Any other witnesses in support? Witnesses in opposition? Seeing none, committee member questions, comments? Senator, I have just one question.
Sure.
Again, my understanding is this simply conforms the rules as applied to charter schools that already exist in public schools, and you mentioned private schools. School districts do have a right under certain circumstances to limit certain constitutional rights in terms of safety issues on school grounds and that sort of issue. But my understanding is this is simply conforming the same set of rules and rights to charter school students as currently exist.
That's correct.
For public school students. And with that, would invite you to close.
Just simply say, can you imagine if charter schools were to, in fact, educate generations and generations of kids, believing that it is okay for authorities that are higher up, maybe a little older, to basically say what you should think, what is okay, what is proper, and having those individuals grow up to be adults. And I wonder who they're going to salute rather than the flag of these United States. That's all. Thank you.
Thank you, Senator. We're going to hold on to that one. We do not yet have a quorum established. We will move on to item 3, and that is your Senate Bill 650.
Thank you very much. This bill basically provides additional protections to UC whistleblowers. This bill comes because of a court case of Mulaski and UC Regents, and in that particular case, the judge did in fact invite legislative fix to the concern that was raised, and what basically the judge was saying was that it is maybe the intent of the legislature not to leave UC whistleblowers out of that particular protection that is enjoyed by all state employees. However, unless it's clearly indicated that, then he needed to rule against whistleblowers. And so this bill simply addresses a court case at the instruction of the judge. And with that, urge an aye vote.
Thank you, Senator. Witnesses in support.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We are here in strong support of this measure. Whistleblower protection is a very important protection for workers so that they're not faced with the decision of having to risk their job in order to do what they know is right. It's essential at a public institution using public funds that workers who have the most knowledge about what is actually happening have the freedom to come forward when they know that the law is being violated or that there's misconduct. So we think that this is an important bill both for those workers and for all of us as taxpayers and as Californians. Thank you.
Mr. Chair, members, David Bala Hawkins, California Faculty Association. This process has worked well at the CSU. Our employees feel that they have been given the appropriate protections to divulge mishandling of funds or mismanagement, and we believe the UC system will also benefit from this. Thank you.
Thank you. Other witnesses in support, name and organization, please.
Mr. Chairman, members of the committee, Shane Gussman on behalf of the Teamsters in support.
Chairman and members, Terry Frank with the Californians Aware, urging your aye vote.
Mariko Yoshihara with the California Employment Lawyers Association in support.
Jim Ewart, California Newspaper Publishers Association, strong support.
Any other witnesses in support? Witnesses in opposition? Seeing none, committee members, questions? Seeing none, would you like to close, Senator?
Just to say that we want the very finest of our state employees. We also want that for our UC employees, and the fact that they know that they will, in fact, be protected if, in fact, they raise some issues and that they are harassed, that there is some protection for them. Urge an aye vote. Thank you.
Thank you, Senator. And again, we'll place that on call pending establishment of a quorum. We'll move to item number 4, SB 662.
Thank you very much, Mr. Chair and members. This is a pretty straightforward bill, and very simply, this is about raising some dollars to help domestic violence shelter. This is an extremely important issue, particularly given these tough economic times. The stress on a family, as you can imagine, may then be acted out in some violence, and domestic violence is not something that we want to promote. We want to deal with it in a most expeditious way. One of the ways is to provide shelter services, and so this is a modest proposal to just simply increase the marriage license fee that has not been changed since 1993, which is $23, and to increase it by $10, and the dollars would then go for the domestic violence program. We did, in fact, make a change, and that is as an opt-in, so that hopefully this will get everybody's support along with the governor. So with that, urge an aye vote.
Thank you, Senator. Witnesses in support?
Hi, I'm Beth Hassett, Executive Director of WEAVE in Sacramento County. We're the domestic violence and sexual assault agency serving this county. And we last year opened a new 12,000 square foot safe house that we are running with a skeletal staff because our funding has been cut so severely over the past year. And in these hard economic times, we are seeing families that are increasingly stressed, and the women staying in our shelter are in the very most violent of situations, often being chased by gang members. Their perpetrators are often armed or career criminals. They're the most fragile victims that we serve, and we have a decreasing number of resources to do so. Lest you think this money would not go very far, given how many marriage licenses were issued in the county of Sacramento last year, this would be 2 full-time advocates for us. That's an entire staff shift worth of advocates for us. We only get the marriage license funding from our county now. They have cut $450,000 since last year of our funding, so we really depend on this. And I realize that my county would need to opt in. I would love the opportunity to encourage them to do so, should I get your aye vote today. Thank you.
Kendra Harris with the California Partnership to End Domestic Violence. We're the statewide coalition that represents a unified voice on domestic violence policy. First, thank you to Senator Yee for authoring this important measure. Marriage license fees have supported domestic violence shelters for more than 30 years. Shelters that are, as Beth mentioned, mandated to provide core services for 24 hours a day, 7 days a week, with highly specialized and trained staff. We have seen that the declining economy has contributed to an upswing in violence in the home, as well as a decrease in public and private funds. This is a dangerous combination that leaves shelters and victims that they serve in a very vulnerable position. So on behalf of domestic violence victims and their families, we ask that you support SB 662. Thank you.
Thank you. Other witnesses in support?
Philip Ong on behalf of the California Coalition Against Sexual Assault, standing with our sisters at the DV side in strong support. We thank Mr. Eve for carrying this bill.
Nicole Wertelman on behalf of the City and County of San Francisco. In the last 6 months of 2008, San Francisco had to turn away almost 600 individuals from shelters, and this funding would go a long way in helping that problem.
Rebecca Gonzalez, National Association of Social Workers, California chapter. Social workers often see victims of domestic violence, and this bill will help keep shelters open. Thank you. Bye-bye.
Thank you. Other witnesses in support? Any witnesses in opposition? Questions from committee members? Seeing none, just to be clear, Senator, this provides counties the right to opt in. It doesn't mandate the counties. The counties would have to vote if they wanted to raise this assessment if it's passed here. Is that correct?
That is correct.
Thank you. Would you like to close?
Just urge an aye vote.
Thank you. We're going to keep that one on call as well, pending a quorum, and we'll move to item 5, SB 782.
Mr. Chair and members, this is one of those bills where we put in quite a bit of work over 2 years, and the issue is the following. What we have seen time and time again are situations where you have victims of domestic violence who are already facing some rather difficult social, emotional problems, but because of that particular situation, they are one step away from being out in the street, being homeless. And the reason for that, and I can understand, is the fact that when you are a renter and all of a sudden you hear a lot of the landlord or other tenants may hear a lot of commotions, they hear a lot of police calls, on and on and on, and you start wondering, well, is this a good tenant? And so what has happened in the past is that because of those kinds of actions and behavior, they are considered nuisance, and therefore to abate that nuisance is eviction. Because these are rather vulnerable individuals, victims, we ought not to further victimize them by saying, well, because you are trying to address this particular issue by calling to authorities, by standing firm of not being abused, you are then being threatened with eviction. And so what this bill tries to do is to help and moderate that particular situation. And how does it do it? Number one, what it will do is to say that if in fact you are a tenant and you have evidence that you are a victim of domestic violence, then that would in fact abate any argument that this is a nuisance and therefore you ought to be evicted. Now, in fairness to the landlord, what we're also saying is that you as a victim of domestic violence, if you somehow continue to invite your abuser into your facility, into your apartment, then you can't argue that particular point anymore. If you are aiding and abetting that particular nuisance, then we're not going to allow you to continue to stay there. And so what we're trying to do is to provide housing for these individuals and through no fault of their own, somehow find themselves in this particular situation. We have taken some amendments that hopefully have addressed a lot of the opposition. One key amendment that we took was that this bill only applies to the victim of domestic violence. And if we're talking about a co-tenant who happens to be the abuser, it is silent on it. I would rather that we would capture those individuals, because those individuals who are abusers, albeit co-tenant, need to be out of that situation. But given the realities of what we have to work with, that's not possible. And so that's where we're at, and with that, urge an aye vote.
Thank you. Witnesses in support?
Malia Schultzman, attorney, National Housing Law Project in Oakland. To illustrate why this bill is so critical, I'd like to share a client story with you. The client's name is Sandra, and Sandra was severely beaten in her rental unit by her former partner. She did everything that a victim should do. She got a restraining order. She cooperated with law enforcement. She gave a copy of that restraining order to her property manager, but shortly thereafter she received a notice to terminate her tenancy. And if she had known that that would happen, she would have never taken that really important step to protect her safety. Victims need to be able to seek a restraining order or a call for law enforcement help without fear that they will be evicted, and this bill would help them do that. We have seen that these types of bills can help prevent victims from becoming homeless. Under the Federal Violence Against Women Act, or VAWA, thousands of landlords throughout our state are already barred from evicting tenants based on incidents of domestic violence. And these are all Section 8 landlords, again, who already are subject to this type of protection. And we've seen under VAWA that while it's not frequently used by tenants in our state, it has a very extensive impact on their lives by protecting them from homelessness. I want to briefly touch on the lock change provisions of this law. We do a lot of trainings for property managers, landlords, housing authorities on addressing domestic violence in rental housing. And a question we often get is, If a tenant comes to me, she has a restraining order excluding a co-tenant from the unit, can I change the locks and not be liable for an illegal lockout? And right now we have to tell them that it's not clear under our state law what would happen in that case. This bill clarifies that if you have that restraining order excluding an abusive co-tenant from the unit, the landlord can change the locks without facing liability for an illegal lockout. We have been working very hard on this bill with all of the groups who are concerned. We recognize that there might be some more work to do, and we're happy to continue doing that work. So I thank you for your attention to these considerations.
Thank you. And before we go to the next witnesses in support, we do have a quorum present, I believe, and I'd ask the clerk to take roll.
Fuhr. Here. Tran.
Here.
Brownlee. Evans. Hagman. Jones. Knight. Monning.
Here.
Nava. Huffman.
Thank you. Quorum's established, and we'll move forward. Next witness in support.
Kendra Harris again with the California Partnership to End Domestic Violence. We're pleased to support this measure. We believe that it provides important eviction protections to domestic violence victims that wish to stay in their homes. At a time when DV shelters are increasingly getting calls for emergency housing, it is critical to ensure that survivors of violence and their children can stay in their homes safely. We ask that you support this measure. Thank you.
Nicole Wertelman on behalf of the City and County of San Francisco, also in support.
Deborah Carlton with the California Apartment Association. I want to thank the author for taking the amendments that we requested, and we actually have removed our opposition and have taken a neutral position.
Thank you. Any other witnesses in support? Any witnesses in opposition? Please come forward.
Oops, there we go. Mr. Chairman, members of the committee, Ron Kingston representing the Apartment Association California Southern Cities. First of all, I want to say that we're deeply appreciative of working with the author and particularly his staff, that all of which we have spent countless hours last year and particularly this year. And this year has been a sea change of cooperation, and for that we're deeply appreciative. I want to focus on Section 4 of the bill and indicate to you, first off, that we really do want to see that this section be worked out. This section really devotes itself to where the landlord or manager, as the case may be, is barred from terminating a tenancy of a victim of domestic violence. And the two issues I want to raise of concern, and we would like to work with the author and particularly the staff, Mr. Clark, as this bill moves forward, but prior to the bill being taken up on the floor of the Assembly, is as follows. The first issue, and this all mostly appears and unfolds on page 7. It starts with line 6 and barely goes over to page 8. We're very concerned that the following fact pattern hasn't been resolved and needs to be resolved. If the aggressor continues to enter the property, poses a threat to not only the victim and also the other tenants, our 3-day notice to correct a condition such as this becomes meaningless. We need to have some type of remedy to make sure that we can continue to protect the tenants, existing tenants, as well as the victim. This bill doesn't quite get there as yet, and we would like to work with the author to really, really resolve this very critical problem. Second, and
okay, you need to wrap it up.
Okay, I just heard that.
Okay.
Time. On page 7, lines 34 through 36, it says that we aren't liable to the other tenants for compliance with this section, yet we remain liable to the victim for everything else that could arise. We would suggest that it really be a comprehensive standard. Woman is taking protective action. We believe we do everything we can. We shouldn't be held liable to her as well as the other tenants, as the bill so indicates, and we would hope that that is resolved. Thank you.
Thank you.
Mr. Chairman and members, I'm John Smock, representing the Apartment Association of Orange County. We've worked very closely with the Senator's staff and your staff, and as Mr. Kingston said, this is a sea change. We remain concerned about the lock issue, which appears primarily on page 8 at, I'm sorry, page 5, lines 16 through 24. This is the ability of the tenant to change the lock without having informed the landlord or given the landlord an opportunity to do it first. The bill is structured to require a tenant to give the landlord notice, first crack at changing the lock. Landlords now are moving much more into the area of very sophisticated and expensive locks that are very easy to change. You stick a master in, rekey, and pull the master out. It's a 10-minute or less operation. And we're concerned about the self-help provisions without giving the opportunity of a landlord to make that change first. We hope that we can resolve this as the bill moves along.
Thank you. Other witnesses in
Mr.
support.
Chairman, members, Steve Carlson on behalf of the Apartment Association of Greater Los Angeles and the Santa Barbara Rental Property Association. Regrettably, we remain opposed. We certainly appreciate all the efforts that the author and the committee staff has taken to deal with this. Some of the committee members and staff, and I know Mr. Jones, when he was chair, we worked very hard on a bill by Mr. Liu several years ago, which went in a completely different direction.
I am going to have to ask you to limit your testimony because we've had 2 witnesses testify in opposition already. So if you could be very concise, to let you have a minute.
The bottom line is that if a victim opts not to avail him or herself of the opportunities under the Ted Lieu's bill a couple of years ago, which allows to get out of the lease without penalty, even the issues about willingly come back and all that doesn't stop a person from knowing that this person has not moved to a place of safety and anonymity. And we realize it's a very difficult policy choice here, but if this person keeps coming back, a protective order doesn't stop somebody from walking in the door and really endangering other people in the building. And we don't know, especially with a group of small landlords, it's a very, very difficult situation for them to deal with. And unfortunately, our clients and our members are very troubled by their tying their hands to be able to react to a situation that endangers others. And that's really why we have to remain regretfully opposed.
Thank you. Any other witnesses in opposition? Seeing none, committee member questions. Mr. Jones?
Right. Before the witnesses depart, I guess I just wanted to have a little bit better understanding. Mr. Carlson, what are you proposing as an alternative?
Well, unfortunately, we haven't come up with, I think, a good one. The bill does provide liability limitation to a landlord, but we still have an ongoing obligation to protect other tenants, and also there's a quiet enjoyment issue, and if we have people moving out of the building because of a constant situation that we can't deal with, it's just troublesome, especially for a bunch of small landlords to try to deal with, which is most of our members. So I don't know that we have a good one. We thought that the Lieu bill was the appropriate reaction last year. It's only been in place a couple of years. Let's let that continue to work. Let's see how the San Francisco ordinance is working. That's only been in place a year, upon which this was based. We just are troubled by that we're all of a sudden going from land. It's hard to advise a small owner how to react in a situation like this. It really is.
And then on the lock issue, I guess I'm curious whether the representatives of the apartment owners, if this was structured in a way that gave the tenant the opportunity to ask the landlord to change the lock, and if the landlord did so instantaneously, great. But if the landlord didn't, then the tenant could avail himself or herself of this recourse. But I think what Mr. Yee is trying to contend with, and what the proponents are trying to contend with, is the imminent danger presented by the aggressor and the need to protect oneself and change one's locks immediately. So I guess, are you proposing then on the lock issue that there would be some structure where if you asked, you'd get immediate lock change, or would you have to wait some period of time?
The bill right now provides as follows. The landlord has a 24-hour notice he has to act within 24 hours upon notice and furnishing of the restraining order or emergency order. In two different situations, one where the aggressor is in the property and one where the aggressor is not in the property. We would suggest that at least the landlord be given first crack at doing this, because they invest many thousands of dollars, as Mr. Smock mentioned, to a master lock system for the entire complex in most cases. We would prefer receiving that notice, acting on that notice, even possibly in a much more expedited time frame. But give us the opportunity to provide that level of safety. Now, there are sometimes, as it is argued, that the woman feels threatened, immediately threatened, and needs to take action following the police report or receiving the TRO. And that's kind of the push point where we're trying to figure out, is there a middle ground between where the woman feels immediately threatened, where she wants to make the lock change for all exterior locks, and where we are given the opportunity to make the change and accommodate the request.
But if you could agree to doing it instantaneously, that might solve that problem. I mean, upon request.
Yeah, we are working on that, and I just don't think we're going to be able to do that in the committee hearing today.
Okay. Well, in any event, appreciate the author bringing forward this measure and appreciate his work on it.
We're going to go to Mr. Fuhr, who has returned. He'll be reassuming the chair role here when we finish with this bill. But Mr. Fuhr, you had a question.
Thank you, Mr. Chair. I have to say, I think that if you took a poll of the committee members, they might prefer to have the status quo remain in place, but that's okay. I want to pick up on Mr. Jones' point, Mr. Carlson, with you, because I think all of us are extremely sensitive and sympathetic to the concerns of a landlord in a small building, grappling, often the landlord is going to live there, him or herself, grappling with how to deal with a horrendous situation where there are no easy answers. So, sometimes in a committee hearing on a bill, there are two starkly different perspectives. This is not one of those situations. We're all trying to figure out what works best, right? But I do think that the natural consequence of your position at the moment is that typically but not always, a woman who is the victim of domestic abuse would, under the approach without the bill, which is the approach that you're sort of advocating at this point, be in the position of being kicked out of her apartment and maybe having no place else to go. As we know, at least for many years, and I think it's still true, the plurality of people who are homeless are single, are women who are parents. Can't afford first, last, and security and have no place else to go, and if kicked out, might be thrust into that very position. So that's the real-life conundrum here. I think we all get it. And your opposition would, again, I'm sympathetic to the point that the bill doesn't resolve every problem created by this horrible dynamic, but the absence of the bill makes the burden fall pretty much exclusively on a woman perhaps with small kids. And that's a tough way to go. So should you have an alternative as the bill moves forward, I would be interested in learning about it too. I think everybody has done a tremendous job of working very closely with the committee staff on this for a long time, and that's terrific. For today, I remain supportive of the outcome that we have in the absence of a better alternative.
Thank you, Mr. Chair, and that's why it's such a difficult issue for me even to get up and talk about, but again, our members are just say, God, Steve, what do I do on this? It's a two-part test in order to, ultimately for the owner to be able to say, okay, it's just not working. It just has to leave. And the two-part test is that the abused person has to willingly invite the abuser back, which is an item of proof that may or may not be, which puts a bar up there. That's a little difficult. And the owner has to make a decision that he reasonably believes that it's that way. Maybe it shouldn't be a both test. Maybe it should be an or test, and maybe that there's something there. because the person may not have invited them willingly back, but the person is there. The abuser knows where the victim is because the victim has opted not to avail him or herself of the opportunities under the Lou Bill for very good reasons, perhaps. And he keeps coming back, or the abuser keeps coming back.
No, I think we get it. The point is that for today, the bill before us is the product of perhaps 10 months' worth of very hard negotiations among many people of goodwill trying to find the right answer. I'm sure the author is open to further discussions, but they have to be concrete with a positive alternative for it to be valuable here.
No, and I appreciate that, and I appreciate your comments, Mr. Fuhrer.
Thank you. Any other questions from committee members? Seeing none, Senator Yee, would you like to close?
Thank you very much, Mr. Chair. And let me say to Steve Carlson, he represents his clients very well, and I still hold him in high regard and want to continue to work with him. But the reference that Mr. Carlson made about Assemblymember Lou's bill is one solution to this particular issue. My solution is a really different one. With the Lou solution, basically what it allows is for the tenant who's been abused to just simply terminate the contract and to leave that particular facility or leave that particular apartment. The problem is that in a lot of other places, you don't have a whole lot of options out there. There are not a whole lot of units that are easily rentable in a particular situation where you have to pay a deposit first month and on and on and on. So that's part of the dilemma that a lot of abused women are facing. Relative to the lock, we have taken amendments to address what the opposition is saying. I think this comes in your analysis, so it's not my interpretation, it's your interpretation, page 5 on the lock change provision. In that, it basically says that notice is given 24 hours, and if you don't respond, then the tenant can, in fact, make the change. In the case where it's a co-tenant, then the bar of proving that you are a domestic violence victim becomes higher. And when you provide that proof, court document, then again 24 hours. And so I think that we've addressed that particular issue. Mr. Kingston, he still has some concerns, but I would just like to reference, I think, on page 6 of your analysis, where there are 3 conditions in which the landlord can still evict. And one of them, on item number 2, the landlord reasonably believed that the abuser posed a threat to other tenant, either physically or the right to quit possessions of the premise. So I think that we have worked for 2 years trying to find a rather balanced approach. I think Mr. Fuhrer makes a good point. We want to find a balance of protecting the victims, but then yet respecting rights. I think that this goes a long ways in terms of trying to do that, and which I urge and I vote.
Thank you, Senator. I see Mr. Jones has a final question.
Something you said in your close. There's a discrepancy between, or an inconsistency between page 5 of the analysis, which suggests that in all circumstances the lock change can only occur after 24 hours notice to the tenant, and the bill on page 5 at line 16, which suggests that in some cases a protected tenant can change the locks without the landlord's permission as long as they subsequently provide permission. And I think it was that latter point, if I'm reading the bill correctly, that the witnesses were concerned about. And so if I understand the bill correctly, putting the analysis aside, there is an opportunity for a tenant to change the lock without prior permission. And I think the concerns raised by the representatives of the apartment owners was that they'd like to have some conversation with you about seeing if there might be some middle ground that would at least give them first opportunity. And what I was exploring in my question was, gee, if they'd be willing to do it instantaneously, then what is the tenant really lost? So I want to make sure I'm reading the bill correctly, though. There is in the bill an opportunity for the tenant to change the lock himself or herself before getting permission, correct?
And that's correct, and that's part of the conversation that we will continue to have with them.
Great, thanks.
Thank you. We'll entertain a motion now. A quorum's been established. Moved by Ms. Brownlee, second by Mr. Fuhrer. Clerk will call the roll.
Fuhrer.
Aye.
Fear, aye. Tran, Brownlee. Brownlee, aye. Evans, Hagman, Jones. Jones, aye. Knight. Monning.
Aye.
Monning, aye. Nava. Nava, aye. Huffman.
That'll be on call. And Senator Yee, we're going to go now back to our chair, Mr. Fuhr. We'll move to item 12. That's your final bill today, SJR 24. And next in order would be Senator Cedillo is on deck. Thank you.
Thank you very much.
Sure.
Mr. Chair and members, let me, as a preface, talk a little bit about this whole issue about violence against women, domestic violence, and so on. In my former life as a child psychologist, I saw on a daily basis some of the ill effects of this particular condition on not only the adults but also children. And it was the children that really tore my heart apart on that. Literally, when you allow domestic violence to occur, and oftentimes you are, this occurs in a captive a situation whereby you're doing it in a home, and oftentimes you've got kids there. And the lesson that we are teaching our children, our boys, is that if you are angry, if you are frustrated, it is okay to hit, it is okay to beat, it is okay to kick around mom, it is okay to kick around women. And if that's what it takes to get compliance out of women, that's what you should do. And then what it teaches our girls, our daughters, is that you have to, when you grow up, allow men to do that to you, because that's just the way it goes. Your mom suffered like that, your grandmother suffered like that, and that's just the way of life. And for us to then grow our children, our boys and girls, with that kind of an attitude, with those kinds of value, it's just something that's absolutely horrible to me. It just perpetuates the violence in our society. And so anything that, everything that one can do, should be directed at how do we lessen that kind of violence, eliminate that kind of violence in our society, in this world. That's what this resolution does. It just simply urges Congress to pass the International Violence Against Women's Act. It provides a whole array of actions that is hopefully going to stem this particular tide of violence against women, not only in this state, this country, but this world. And with that, urge an aye vote.
Thank you very much. Senator, your first witness in support. Oh, and by the way, before we turn out, I want to say on the record how much I appreciate the terrific work of Mr. Monning serving as chair this morning. Thank you very, very much. Now your first witness, please.
Julia McPherson with CARE USA. I would like to thank Senator Yee for inviting CARE to testify in support of SJR 24. Violence against women and girls is one of the most widespread but least recognized human rights abuses in the world. It reduces women's and girls' contributions to development, inflicts costs on national economies, and therefore undermines poverty reduction efforts. As a leading international humanitarian and development organization, CARE has dedicated itself to fighting root causes of poverty in the world's poorest communities. Our approach to working with women recognizes the role that violence plays in perpetuating poverty and inequality. We are heartened to see the California legislature's efforts to draw attention to this important issue. As a global leader, the U.S. must play a pivotal role in fighting violence against women. This can be done by passing the International Violence Against Women Act, which calls for a comprehensive strategy to reduce violence against women and girls worldwide. We urge the California legislature to pass SJR 24 and continue its efforts to ensure passage of the act in Congress. Thank you.
Thank you for your testimony. Next witness in support.
Hi, my name's William Butkus, staffer in the Amnesty International's Western Regional Office. Amnesty is the largest human rights nonprofit in the world with 2.8 million members in over 150 countries, and we have almost 70,000 members in California alone. The United Nations Development Fund for Women estimates at least 1 in every 3 women globally has been beaten, coerced into sex, or otherwise abused in her lifetime. Violence debilitates countries, impedes economic progress, prevents women from raising healthy children. International Violence Against Women Act creates a comprehensive, integrated approach to addressing violence and and places women at the corner of the U.S. Foreign policy. The bill supports measures to prevent violence, protect survivors, and bring perpetrators to justice. It contains best practices, provisions for preventing and responding to violence against women during the times of peace and times of conflict. Legislation was developed by Amnesty International, Family Violence Prevention, and Women Thrive Worldwide, with input from 40 international and 150 U.S.-based groups with relevant expertise. It has bipartisan support from Senator John Kerry, Democrat, Barbara Boxer, Democrat, Susan Collins of Maine, Republican, Olympia Snow, and others. The support of the California legislature would be extremely helpful in encouraging Congress to pass a VAWA, which would, again, save the lives of millions of women and girls around the world. Thank you very much.
Thank you for testimony. Next witness in support.
Mariel Garcia with the Amnesty International Local Davis Community Chapter. I'm here representing local members of Amnesty, which support SJR 24 because it addresses key issues facing women internationally. A lot of these issues have been ignored, and help women internationally by alleviating poverty and increasing cost effectiveness of foreign assistance to women.
Thank you for your testimony. We have two witnesses in support, and the other people identify themselves for the record in support, so thank you very much. Other witnesses in support?
Kendra Harris with the California Partnership to End Domestic Violence in strong support.
Thank you for your testimony. Other witnesses in support? Are the witnesses here in opposition to the measure? Seeing none, are there questions or comments from members of the committee? The bill has been moved. Is there a second? The bill's been moved and seconded. Mr. Yee, do you wish to close?
Thank you very much to your staff and to members. Urge and I vote.
Thank you very much. Senator, call the roll.
Fear?
Aye.
Fear, aye. Tran? Brownlee? Brownlee, aye. Evans? Hagman? Jones? Jones, aye. Knight? Monning?
Aye.
Monning, aye. Nava? Nava, aye. Huffman? It's on call. It needs one more.
That bill is on call, Senator. It needs one more vote. Our final presenter will be Senator Cedillo here on item 11, SCR 58. Welcome, Senator. And I will use this opportunity to say again, for those listening in the building, this is the last measure. We're then going to convene the committee and call the roll on all the measures before us, so please join us for that opportunity. Senator Cedillo, welcome.
Good morning, Mr. Chairman. Thank you for this opportunity. You've had a long morning, and so I will be brief. This resolution, which calls for our body to condemn hate speech focused on Latinos, is particularly relevant at this time. When you think of the policy measures that have been before this body as they relate to the movement of Latinos in our society, the impact on the education for Latinos, the services provided to them. We live in a time where there is an intense anti-immigrant hysteria, and that has policy impacts on the broader Latino community in general. And so we bring this forward based upon FBI reports which indicate that Latinos comprise disproportionately about 62% of crimes motivated by bias against the victim's ethnicity or national origin. And we note an extraordinary increase in groups with an animus towards immigration reform, and in many instances that has led to violence, and no doubt a policy which results in the death of literally, sadly, unfortunately, thousands of persons here in our borders. So I ask for this body to take that as a note and to move this resolution forward.
Thank you, Senator. Are there witnesses here in support of the measure? Are there witnesses here in opposition to the measure?
I'd like to move the measure.
The measure has been moved. Is there a second? There is a second. It's been seconded robustly. Are there questions or comments from members of the committee? Please, Mr. Knight.
And I understand these SCRs and AJRs and all these. Or else what? We condemn them and they continue to do what you say they're doing, then what?
then we create a consciousness and an awareness and an understanding that prevents the type of activities that took place, for example, in the 1930s when we kicked out 2.5 million Americans who happened to be of Mexican descent. We create a consciousness that does not permit us to engage, because we have to ask ourselves, how is it and in what circumstance, what atmosphere existed when we incarcerated an entire Japanese American community of citizens? And so, or what is a construction of an atmosphere that goes unchallenged, that allows hate crimes to exist not just individually but as public policy? That's the or what.
Okay, and I understand your examples, but that was government involved in that. Government doing that.
Government responding to a popular circumstance. People doing what was popular and not what was right. Government is made up of people. We are the people.
Understandable.
You are and I am the government.
Understandable. Government did the action. The action that you're talking about today is the private industry, is the reporters out there, is the media, the internet, the people that are reporting maybe not the way you would like to see it, but maybe the way that they see it or the way that their company wants to see it. I don't know if that's the place for government to step over those bounds and say, you're not reporting it the way we want you to report it. We want you to do this.
It's absolutely the place. We don't permit you to shout fire in a crowded theater.
Oh, absolutely not.
Absolutely.
And I don't believe that they are stepping over their bounds of the First Amendment. They're reporting it in a way that you do not agree with.
No. There are duties, modest, basic threshold duties and obligation, and I'm simply asking that they comply with that. Hate speech is not protected speech. And so that's all that I'm asking. And I don't suggest that anyone should agree with my point of view. I think there's a basis for my perspective, but I recognize the robust debate that creates our democracy. I support that. But this is not what I'm talking about.
Thank you very much, Mr. Knight. Other questions or comments from members of the committee? Seeing none, Senator, do you wish to close?
Yes, I thank you for your consideration of this matter. This is an extraordinary time in which we live. I am not suggesting that we curb First Amendment rights, but I am suggesting that we do require that the media and restrict itself to the limits of the First Amendment, that it does not engage in a practice or policy that is the equivalent of shouting fire in a theater. These are difficult and challenging times for us. Change is difficult for our nation. The American people are distressed, confronted with a difficult economic tumult in our economy and in the global economy. And we should focus on those challenges that confront us. We should not permit hate speech to proliferate our airways. They are a franchise. They are a privilege. It is not someone's right to be on the air and to proliferate hate speech. That is not permissible, and we should speak out against that. We should not hesitate or have any qualm. The FBI has linked this hate speech to crime, crime that is not permissible. The FBI is not some liberal organization. Doesn't have some agenda other than to protect the American people. The FBI has come forward and brought this to our attention, and we should be responsible and responsive in taking that information and protecting all Americans and all residents of this nation, regardless of their ethnicity, regardless of their national origin, and regardless of their immigration status. As for an aye vote.
Thank you very much. Senator, call the roll.
Fear?
Aye.
Fear, aye. Tran? Brownlee? Brownlee, aye. Evans? Hagman? Jones? Jones, aye. Knight? Knight, no. Monning?
Aye.
Monning, aye. Nava? Nava, aye. Huffman.
Okay, that bill is on call. It requires one more vote.
Thank you.
Thank you. At this point, let's have a motion on the consent calendar. Is there a motion to approve the consent? It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Jones. Jones, aye. Hagman, aye. Knight. Knight, aye. Monning. Monning, aye. Nava. Nava, aye. Huffman.
The consent calendar has been approved. Now we'll work our way through the items on our agenda. Item number 1, SB 392, Flores. Is there a motion on the bill? It's been moved. Is there a second? Second. It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman.
Item number 1, SB 392, Flores.
Hagman, aye. Jones. Jones, aye. Knight. Knight, aye. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill has sufficient votes and is out. Item number 2, SB 438 by Senator Yee. It's been moved. Is there a second? Moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, aye. Jones. Jones, aye. Knight. Knight, aye. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill has sufficient votes and is out. Item number 3, SB 650 by Senator Yee. Is there a motion?
So moved.
Is there a second? It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, no. Jones. Jones, aye. Knight. Knight, no. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill is short one vote and is on call. Next item is SB 662 by Senator Yee. Is there a motion on the bill? It's been moved. Is there a second? It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, no. Jones. Jones, aye. Knight. Knight, no. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill is on call. We'll move to item number 6, SB 1166 by Senator Semidian as amended. Been moved. Is there a second? It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, no. Jones. Jones, aye. Knight. Knight, no. Monning. Monning, aye. Nava. Nava, aye. Huffman. It's on call.
That bill is one vote short and is on call. Item number 8, SB 1222 by Senator Woke. Is there a motion on the bill? Is there a second? Moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, no. Jones. Jones, aye. Knight. Knight, no. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill is short one vote and is on call. Item number 9, SB 1269 by Senator Oropeza. Is there a motion on the bill? Moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, no. Jones. Jones, aye. Knight. Knight, no. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill is one vote short and is on call. Item number 10, SB 1355 by Senator Wright. Is there a motion? So moved. It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Tran. Brownlee. Brownlee, aye. Evans. Hagman. Hagman, aye. Jones. Jones, aye. Knight. Knight, no. Monning. Monning, aye. Nava. Nava, aye. Huffman.
That bill is out. Item number 13 by Assemblymember Monning. Perhaps Senator Monning one day, but Assemblymember today.
We're pulling that till next.
Oh, excuse me. Okay, that's been held till next week. Okay. All right. So we have, yes. This is the kind of collegiality we strive for in this committee. So we have a number of measures that are on call. The sergeant, I'm apprised, has called the members who are absent to direct them to come to the committee for votes. We'll await their arrival and conclude our agenda when they do. We'll be in a very brief recess pending the arrival of the absent members. All right, we'll conclude our recess and go back into session in the Assembly Judiciary Committee. We are now prepared to lift the calls on matters, on a number of matters. Let us first do so regarding item number 3 by Senator Yee, SB 650. Call the roll for the absent members, please.
Chair voting aye. Tran?
No.
Tran, no. Evans? Evans, aye. Huffman?
Okay, that bill is out. Next item is item number 4 by Senator Yee, SB 662. Chair voting aye. Call the absent members, please.
Tran? Item 4.
Item 4, SB 662.
No.
Tran, no. Evans? Evans, aye. Huffman?
That bill has enough votes and is out. Item number 5, SB 782 by Senator Yee. Chair voting aye. Call the absent members, please.
Tran?
Number 5, no.
Tran, no. Evans? Evans, aye. Hagman?
No.
Hagman, no. Huffman?
That bill has sufficient votes and is out. Item number 6, SB 1166 by Senator Simidian. Chair voting aye. Call the absent members, please.
Tran?
No.
Tran, no. Evans?
Yeah, it was amended.
Evans, aye. Huffman?
That bill is out. Item number 8 by Senator Woke, SB 1222. Chair voting aye. Call absent members, please.
Tran?
No.
Tran, no. Evans? Evans, aye. Huffman?
That bill is out. Next is item number 9, SB 1269 by Senator Oropeza. Call absent members, please.
Tran?
No.
Tran, no. Evans? Evans, aye. Huffman?
That bill is out. Next is item number 11, SCR 58 by Senator Cedillo. Chair voting aye. Please call the absent members.
Tran? No. Tran, no. Evans? Evans, aye. Hagman?
No.
Hagman, no. Huffman?
That bill has sufficient votes and is out. Item number 12, SJR 24 by Senator Yee. Chair voting aye. Please call the absent members.
Tran?
Not voting.
Evans? Evans, aye. Hagman? Huffman? It's out.
That bill has sufficient votes and is out. That concludes our agenda. If members wish to add on with respect to votes that we've already taken, they may do so. With the exception of those add-ons, we will be in adjournment. Thank you very much.